Judgment in the matter of the King on the application of Palmer against the Northern Derbyshire Magistrates Court and another.
Lord Richards will explain the court's judgment.
The appellant in this appeal, Mr. Robert Palmer, is a licensed insolvency practitioner. On the 13th of January 2015, Mr. Palmer was appointed one of 3 administrators of a company called West Coast Capital USC Limited. The appointment was made on the basis that the company was insolvent. The following day, the employees working at the company's warehouse in Dundonald were given a letter from Mr. Palmer telling them that they were at risk of redundancy and that the company intended to consult them at a meeting later that day. Shortly afterwards, the employees were handed a further letter signed by Mr. Palmer informing them that they were dismissed with immediate effect. Under the Trade Union and Labour Relations Act 1992, an employer which proposes to make at least 20 employees redundant within 90 days must give notice to the Secretary of State at least 30 days before the dismissals take effect, and it commits an offence if it fails to do so. In this case, no such notice was given by the company to the Secretary of State before the redundancies took effect. The Act goes on to provide that any director, manager, secretary or other similar officer of a body corporate is also guilty of an offence if the company fails to notify the Secretary of State with their consent or connivance or as a result of their neglect. In July 2015, Mr. Palmer and a director of the company, Mr. Michael Forsey, were both charged with this offence, and proceedings were commenced against them in the Northern Derbyshire Magistrates Court. They both entered pleas of not guilty. Mr. Palmer applied to the Magistrates Court to dismiss the charge against him on the grounds that as an administrator appointed under the Insolvency Act, he was not an officer of the company within the meaning of the relevant section. If he was not an officer of the company, then it followed that he could not have committed the offence. The district judge rejected Mr. Palmer's application. Mr. Palmer challenged that decision by way of judicial review. The divisional court rejected his challenge. The issue on the appeal before this court, as it was in the courts below, is whether Mr. Palmer, as administrator, fell within the category of director, manager, secretary, or other similar officer of the company. For the reasons given in the judgment handed down today, the court holds that an administrator appointed under the Insolvency Act is not an officer within the meaning of the relevant provision. An examination of the provisions of the Insolvency Act shows that it is not contemplated by that Act that an administrator is to be regarded as an officer of a company over which the administrator is appointed. Previous decisions of the High Court in different cases that an administrator or a liquidator was an officer of a company within the meaning of the Insolvency Act were wrongly decided. While it would be possible for an officer in the different context of the Trade Union and Labour Relations Act to include an administrator, the Court considers that there are no grounds for concluding that this is the effect of the legislation. The Court holds that the word officer in that context means a person who holds an office within the constitutional structure of the company. For these reasons, the Court allows Mr. Palmer's appeal.